So we're going to pick up today with employment discrimination. Where we left off Tuesday was on talking about the different kinds of discrimination that would show up in employment. We talked about disparate treatment, which is discrimination that's specific to an individual. I didn't hire you because you're Catholic. I fired you because you wore a religious token to work, specific to that employee. Disparate impact was when we had facially neutral, non-discriminatory policies at work, but they resulted in statistically a disparate impact, a discriminatory impact on a class of people. The example was we give 10,000 people a test, a placement test or a competency test for a job. 50% of the applicants are women, 50% of the applicants are men, and only 10% of the male applicants pass the test, and 75% of the female applicants pass the test. Statistically, there's something going on with that test that is discriminatory against the males. Not intentional, but it still has some discriminatory impact. So those are two ways that that might show up. We talked about hostile work environment as being a form of employment discrimination. We also talked about retaliation as being a form of discrimination. If you complain to your employer, your human resources department, your supervisor, that you have been treated unfairly because of your membership in a protected class, then if they turn around and discipline you, fire you, demote you, don't promote you, those types of things, if you suffer an adverse employment decision based on the fact that you made legitimate complaints, then that could also be employment discrimination as well. Now remember, membership in a protected class is a key part of this. If I go to the dean's office every day and I complain to her about how cold it is in this room, and she ends up firing me because she's sick of hearing me complain about how cold it is, that's not going to be employment discrimination, because my complaint was not related to me being treated differently because I'm of my membership in a protected class. So retaliation does protect employees, but it protects them from making complaints about employment discrimination. I know I'm not going to be able to talk this morning. So, employment discrimination is the major federal statutes we study in this class, like Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, the Americans with Disabilities Act. These major federal statutes are overseen or implemented, monitored, carried out by the Equal Employment Opportunity Commission, the EEOC. You've probably heard of the EEOC. It is a federal agency. So we know from our discussion about sources of law that the EEOC as an agency has the power to make rules that are binding on all of us as law. And the EEOC frequently will issue rules and interpretations of some of these employment discrimination statutes. One unique thing about employment discrimination at the federal level is that normally when we want to file a lawsuit, we go straight to court and we file our lawsuit. Somebody rear ends me this morning on University Avenue, that I'm going to go and sue them for the damages that I sustained in my car and my person. If I enter into a contract for the sale of a house and the buyer backs out on me and I want to sue them for it, I just go to court and sue them. In employment discrimination, there is a preliminary step that an employee has to take before they can go to court. And it's called filing a complaint with the EEOC. So if I'm fired by Dean Kidder today because I'm old, or I think it's because I'm old, and I want to sue CSU for discrimination based upon my age, first I have to file a complaint with the EEOC. I cannot go directly to court. So why do we have this? I don't know that I have a great answer for you on that, but the supposed answers are that, well, I do have a good answer for that. The EEOC gets flooded with employment discrimination complaints all day, every day. And our court system would not be equipped from a capacity standpoint to handle all that. So it's kind of a preliminary step that might weed out some of these cases, or that would get some of these cases settled or resolved before tying up the court's resources and time and all that, and the parties' resources and costs. You don't need a lawyer to file an EEOC complaint. So it, in theory, assists employees with the cost of enforcing their rights. They don't have to go hire a lawyer and then have that lawyer file a lawsuit. They just file their complaint with the EEOC. Now, the downside of having to do that is that the EEOC is not a court. So they're not going to decide whether or not you were discriminated against, whether the employee was discriminated against. They don't have the power that a court has to find the employer liable or to award damages or anything like that. If somebody files a complaint with the EEOC will review it. They'll read over it. They'll maybe ask for more information if they feel like they need some. They'll send it to the employer, and the employer has a chance to respond, provide any information that the employer wants to send. And then the EEOC will they'll make a determination. And I said it's not like a court because the EEOC's determination doesn't have any binding power on anybody. But they will make a determination about whether or not there was cause. And once they do that, the employee can go on to court and take that EEOC determination and sue. The EEOC determination doesn't carry any weight in court. So if I file my complaint with the EEOC against CSU and they find that there's merit to my complaint, they issue me my right to sue letter, I've still got to go to court and prove my case. So that's why I hedged a little bit when I told you why the government has set up the EEOC this way. It does probably weed out a lot of cases, I think, and it does give access to employees who might not be ready to go hire a lawyer to sue their employer, but it doesn't necessarily result in, well, I'm hedging again. I guess it results in a little less lawsuits, but it's still a pain for the employer. I'm thinking about it from the employer standpoint sometimes. So if the EEOC reviews a complaint and decides that there's not cause, you still get a right to sue letter. The employee can still go to court and sue, even if they don't get a favorable determination at the EEOC level. And again, none of that is admissible in court. I can't go to court and say, hey, jury and judge, I filed my complaint with the EEOC and they found that my complaint had merit. I got to prove my case all over again. Once we get to court, employment discrimination cases take a little bit different pattern than your normal case. So when we talked early in the semester about civil cases and criminal cases being brought by plaintiffs in civil cases and then being brought by the government in criminal cases, and then the burden of proof is on the plaintiff and the government to prove their case in court. The plaintiff in a civil case, remember, has to prove their case by preponderance of the evidence. In a criminal case, the state or the federal government has to prove their case beyond a reasonable doubt. In an employment discrimination case, the burden shifts. Think about it like the ball is always usually in the plaintiff's court. They got to prove their case. In an employment discrimination case, the ball kind of flips a little bit. Here's how that works. In order to establish a basic case for discrimination, the employee has to allege that they suffered an adverse employment decision. I wasn't hired, I wasn't promoted, I was demoted, I didn't get a raise, I was disciplined, these type things. And then they've got to show that they were a member of a protected class. So again, I can't sue CSU for this room being cold and call that discrimination. So the employee makes out what's called a prima facie case. That's a Latin word that you'll see in your notes. That means a basic threshold case. The plaintiff has met their burden of showing that they were employed or they were a candidate for employment. Something bad happened. They're a member of a protected class, and they tell the court that that's the reason that they suffered this adverse decision. Then the burden shifts at that point to the employer. And at that point, the employer has to give a legitimate, non-discriminatory reason for the action that was taken against the employee. This employee had terrible performance. We ran a background check and they're a convicted felon. We gave them a competency test that we give all applicants, and they failed it. This person did not have the highest score of the interviews of all the people that we interviewed. Legitimate, non-discriminatory reasons. All right, once the employer articulates that, this is all before you go to trial. The employer has to put forth what their reason is. Then the burden shifts back to the employee to show that that reason is pretext or bullshit. That's a very legal term that I like to use. But that's the best way to describe it. Then the employee has to show that the reason that they gave is not the real reason. That's just their cover reason. That the real reason was discrimination. You still got to prove that the real reason was discrimination. We had a good question, I think, Tuesday about how does that happen? What kind of proof do we need? Documentary evidence, employee, what do you call it? Evaluations, depositions. We might take depositions of everybody who was in on the employment decision, the committee that made the decision, the supervising, the hiring manager, the HR people, anybody that had any input into the decision. We're going to want to go before court during discovery and ask them, Ms. Marshall, why didn't you hire Mr. Tebow? Why'd you fire Mr. Tebow? She's going to give us the reason. We're going to check that reason out against all the other people who were in on it and against what any documentary evidence we have to see if that's consistent or see if it's inconsistent and I've got a better case. So everybody kind of has to be on the same page. Remember, I can ask for emails. I can ask for the notes from the interview session. I can send requests for production of documents to get all that stuff. And there may be something in there that says, maybe Dean Kidder has had it up to here and she emails somebody and says, if we don't find a reason to get rid of Professor Tebow, I'm going to murder him. But that actually, I hope she wouldn't do that. That might be a terroristic threat. I might be looking for stuff like that. You know, let's say that Dean Kidder comes back at the lawsuit stage and says, yes, we fired him, but his performance was terrible. Well, I'm going to want to ask them for everything they have that supports that. Because if my performance evaluations are not bad, if my student evaluations are not bad, if I've never been counseled or disciplined or coached about problems, that's going to make it look like their reason was bull. If they've got evidence to support all that, that's going to make it a lot harder for me to show that their reason was bull and that the real reason was discrimination. So we have a burden shifting mechanism in employment discrimination cases. I think that we skipping around a little bit. When it comes to, I'm going back through the protected classes in Title VII here for a second. Race, color, national origin, religion. The law does afford employees the right to make a request for an accommodation. For example, my religion requires that I wear a certain garment over my head. So and that goes against the dress code of the company. I could make a request for an accommodation. Would you let me wear my headscarf because it's a religious thing for me, and I'd like to have an exception to that, an accommodation based on my religious belief. Those are legitimate, but they're not absolute. So an employer is required to make an accommodation where it's not an undue hardship on the employer. They're not required to do things that would cost them excessive amounts of money or that are completely inconsistent with what they do. For example, let's say that I am my religion, I'm making this up. My religion says that I cannot, I have to have a period of silence every day. I can't talk every day until noon, from sun up until noon. I like this. I might convert to this religion. And so therefore I can only teach by sign language or gesturing or putting slides up or anything, but I can't talk to y'all. And I would like that accommodation. They're not required to do that because speaking is an integral, basic part of teaching. That's part of it's an essential function of my job. So they're not required to exempt me from essential functions. Same thing if like I said, well, I have just converted to a new religion, Dean, and our religion prohibits any work on Thursdays. So I'm going to need y'all to like cancel all my Thursday classes or just not give me any, just make me only teach on Tuesdays. They're not required to do that. That'd be a hardship on the school, and it would, I'd be asking for an accommodation to exempt me from an essential function of my job. They're not required to do that. The word that comes into play when we talk about all this, which you, by this point in the semester, probably won't be surprised. Employers have to make reasonable accommodations. That word again, reasonable. The statute doesn't define what reasonable is, but we have books and books of cases where courts have decided whether or not certain specific requests were reasonable or not. So we can go back and look at prior case law, prior decisions, and if we see that courts have pretty much generally upheld a request to wear a headscarf as a reasonable accommodation, then I'm going to bring all those cases with me to court. Those are going to be good for me. If there are a bunch of cases that have consistently held that that is not a reasonable accommodation, then my employer is going to bring that to court. Hopefully my lawyer will be good enough to know before we go to court what all those prior cases say. So that's how accommodations work. Let's talk about gender discrimination for a second. Pregnancy discrimination is specific, obviously, to females, but it does constitute discrimination on the basis of sex or gender. So it's illegal for an employer to make any employment decisions based on the fact that an employee is pregnant. Like, well, let's not promote her because she's going to be out for maternity leave. She just got married. She's 30 years old. She doesn't have any kids. Let's not hire her. The first thing she's going to do after she gets married is start cranking out children. That's highly discriminatory, obviously. Along those same lines, it's illegal for an employer to ask in an interview or even of an existing employee things like, hey, what's y'all's plans on raising a family? Y'all plan on having kids anytime soon?
I mean, that's not crazy.
Right, because in polite society, that might be part of a conversation that we would have between people we know and, but yeah, you gotta be careful about getting into that kind of stuff. Because, and I'm glad you brought that up, Warren. Let's say that I'm just a really nice guy, which I'm not, but I'm a really nice guy, and I care about my employees, and I want to know how they're doing, and I want to know things about their lives because I want to I care about them. And I ask things like that. How are y'all doing? You think about having another one anytime soon? It's part of our conversation. But if that employee later on, and I might have very pure motives in that. I just want to get to know my people and establish a good relationship. But later on, if I don't promote that person or that person gets fired, from a perspective standpoint, when stuff happens to us, we start thinking about all the reasons why and who's to blame. That's human nature. She might be thinking, I bet he didn't hire me because he thinks I'm going to get pregnant. He talked about it all the time. And if we go to court, that makes me look slimy. He was always asking me about my plans for having children, and it just creeped me out. And I'm like on the witness stand being like, I was just trying to care about her. There's really no... So, Mr. Tebow, you make a habit of asking all your employees about their private sex lives and their reproductive habits? No, I'm just trying to be a good boss. So my experience in this area of the law is that when somebody gets fired, it's never their fault, or it's very rarely their fault. It's always because somebody else is picking on them. What's the word I'm looking for? I can't think of the right word. Yeah. So there is one of my clients is the health department out of LaGrange, which is just north of here, and they actually cover 10 to 12 counties up in that area, and each county has a separate health department. And they hired me about 15 years ago to just be on retainer so that they could call me up and say, hey, we got this issue with this employee. We want to fire this employee. What do you think? This issue came up. This person asked for medical leave. Basically, just providing legal advice to their HR department. And I do that because in my former life, I was about to say as a real lawyer. I'm not a real lawyer. But back when I worked for a big firm and all that, I did do employment discrimination law. So I had a background in that. I don't do employment discrimination in any other form now except for advising the health department. But they'll call all the time and they'll say, we've got this problem. What do we do about it? And we talk through it. And mostly it's common sense. Mostly it's things like, if you're going to do that, you're going to discipline this person. or if you're going to fire this person for this, make sure that you warned them. Make sure that you have it written in there that you gave them a reprimand. Make sure that you coached them about it. Make sure that you gave them the opportunity to correct it, so that, I'm thinking ahead, when they file that EEOC complaint and say, I got fired because I'm over 40, and we get our chance to respond, I can respond with all of the performance reviews that were negative. I can respond with all of the written reprimands that the person had. I can respond with statements from managers saying, I spoke to this person about being late every day for a year. Here's the dates I spoke to them. Because I think, from seeing it from the lawyer's perspective of cases where employees win, it's sometimes obviously because the employers have, I know this will shock y'all, but employers do discriminate illegally. They do make decisions sometimes based on illegal criteria. But in the cases where it's a little bit muddier than that, where the employer might have a good reason, but if the employer can't prove that reason or show that reason, it makes it look like they're just making that up after the fact. And so that's one reason why there are a lot of times they'll call up and say, we need to discipline this person or do this. And I'll agree 100% they need to. And sometimes it's bad enough to fire. But if we haven't done our job of documenting it and building the case ahead of time, I tell them not to do it yet. Because I'm afraid of them getting on the witness stand and the other lawyer saying, if this was such a big problem, why did you never put anything in writing? Why did you never reprimand them? Why did you never give them a warning? Why didn't you give them a final warning and say, if this happens again, you could be fired? It just makes it look suspicious. And there are plenty of times when it's completely legitimate. But I just want them to be able to prove it. There is a concept in employment law called constructive discharge. And it's mostly a state law thing. So it's not something that you would do through the EEOC and sue in federal court under a federal employment statute. But constructive discharge is this idea that they didn't fire me, but they all but fired me. They made my working conditions, my life so intolerable that they basically forced me to quit. I couldn't go on working there. Constructive discharge. And that's usually going to be, the reasons will be because of usually some sort of harassment or hostile work environment or things like that. It could be non-discriminatory. It could be something like they just expected me to do the work of 5 people and I just finally broke under the weight of it. The only thing I really want you to know about constructive discharge is that it is possible for an employee to have their lives be made so miserable that they are constructively fired. They're, for all intents and purposes, effectively fired. And if that happens, they may have a cause of action under state law. All right, that takes us to sexual harassment. So sexual harassment takes a couple of forms. One is hostile work environment. We talked about that already. The environment was just so toxic in a sexually charged or sexual nature that I was I couldn't work, couldn't do my job. It was uncomfortable. No one should have to endure that. The other kind of sexual harassment is quid pro quo. That means something for something. That kind of harassment looks like this. We don't have a hostile work environment at all. Our environment is fine. I'm not subject to, use myself again, I'm not subject to a sexually charged environment where people are making bad jokes or showing bad pictures or doing that kind of thing. But in my performance evaluation meeting with my supervisor, she tells me, hey, let's go have your performance evaluation down at the Motel 6. I know how you can get an A on your evaluation this year. That's something for something. If you do this, I will give you this. Works the other way too. If you do this, I won't fire you. If you do this, you'll get to keep your job. That's quid pro quo sexual harassment. Illegal, just like hostile work environment is illegal. Hostile work environment, could be from somebody saying stuff to the employee, but it also could be that nobody ever said anything to the employee. They just talked about stuff around the employee where they could hear it, or they sent emails or displayed things that, when taken as a whole, renders a workplace environment hostile to that employee. This is a sexual harassment is a place where retaliation comes into play a lot. Employees are often afraid to make reports of sexual harassment because they're not anonymous. The employer is going to have to address it with the person that they make the complaint against. So that in and of itself creates a really uncomfortable situation in the workplace. I am at the part of the outline on age discrimination. I think we've talked about that. Age Discrimination in Employment Act, that's from 1967, prohibits discrimination on the basis of age for individuals 40 years and over. Let's talk about disability for a second. The Americans with Disabilities Act, the ADA, y'all probably heard of that. It covers a very wide range of requirements, not just in employment, but in access to like buildings and things like that. The ADA, so it reaches beyond just employment. Like when we see ramps and handicap stalls in the bathroom, those things, those are because of the ADA has mandated that those type things be made available in public buildings. But it also requires, for our purposes, the ADA says that employers must make reasonable accommodations to employees based on their disability, if the accommodation is based on a disability. So I want to make sure that this is an area where hopefully by this point in the semester you will hear what I'm about to tell you and say, that sounds like a nightmare for the courts to figure out. The ADA just says, well, the ADA defines disability as a physical or mental impairment that substantially limits one or more major life activities. Period. It doesn't say what substantially limits means. It doesn't give us a list of major life activities. That's left for the courts to interpret on a case-by-case basis. And we build up a body of case law over time that we can go back and research and say, hey, I have schizophrenia. Let me look up all the cases with schizophrenia. Has that been held to be a disability that limits one or more major life activities? Yes. What have courts found in the past are major life activities? We could go back and Google that, but we don't Google but we search in the research bank. And we can pull up all the cases where courts have defined what is and what isn't a major life activity. And in that way, we have a better idea of, as employees, what we could ask for as an accommodation as an employer, is what we might or might not be required to give, what is reasonable. So it's not only, I'm going to continue on this definition for a second, physical or mental impairment that substantially limits one or more major life activities. It's also a record of such impairment. So if I have let's say that I have a record of seizures, but I'm currently symptom free. I haven't had a seizure in a long time. I take some medication that, or either my problem just has not manifested itself in any way. If my employer makes a decision based on them regarding me as being disabled or my record of being disabled, that could be discriminatory. Let's say that I don't have a disability of any kind, but my employer thinks I do. They assume that I do, not based on anything I've done. They just made this false assumption. And they make an employment decision based on them regarding me as having an impairment. This happened a lot back in the 80s when AIDS first came on the scene. And the homosexual men were discriminated against because they were regarded as a liability for getting AIDS or having AIDS or whatever that would be. They might not have had anything, but they were regarded as being disabled or susceptible to a certain disability. So those are three ways that you can have a disability under the law. You could have an actual physical or mental impairment that substantially limits major life activity. You could have a record of that, or you could be regarded as having one of those. So we can't be discriminated against in employment decisions based on our disability. Let's talk about accommodations for a second. The ADA also gives employees the right to ask for an accommodation. Here's a great example. I have a problem with my legs that I can't stand for long periods of time, let's say. And I request that CSU provide me a chair like that over there that I can sit in. I'm entitled to reasonable accommodations. That's a reasonable accommodation. I work a job at an information booth at the airport. I need a chair to sit in. I request an accommodation. They give me a chair that's high up that I can be at counter level and do my job. That's a reasonable accommodation. I need to take scheduled breaks in the morning and in the afternoon to take insulin shots. I need a refrigerator somewhere in the building where I can store my insulin. Those are all reasonable accommodations that a person might ask for. Okay? A tricky part of the ADA is that you still have to be qualified to do the job with or without the accommodation. This is something that always confused me when I was practicing law in this area. I'd have to go back and sit down and sort out in my mind with or without an accommodation. I've still got to be qualified to teach with or without the chair. I'm qualified without the chair. I just need the chair to help me. You can't ask, so another way of saying that is you can't ask for an accommodation that makes you qualified for a job you weren't qualified for without it. Right? I apply for a job as an air traffic controller, and I'm legally blind. I can't request an accommodation that they give me a person who has perfect vision to look at the radar for me. I'm not qualified for the job without the accommodation. So it's not intended to make somebody who's not qualified all of a sudden qualified. It's just intended to enable somebody to do their job based on their disability, with their disability, in spite of their disability. That makes sense. The case that you're going to read for Tuesday involves an employee who was fired, and he claimed that it was because of a lot of reasons. And we'll get into a little more detail about that on Tuesday, but I want you to pay attention as you're going through that case. What accommodations he asked for and what were reasonable and maybe what weren't reasonable. Now, when we talked about religious accommodations a minute ago, I said that the employer was not required to make an accommodation that would pose an undue hardship. Same thing for the ADA. If I requested that CSU build a new entrance to this classroom right out here just for me, and I can't really think of why that would be a reasonable request, but assume it is, and it would cost them $2 million, they're not required to do that. An employer who has 50 employees, small businesses, they're not required to make accommodations that would bankrupt them or make them go out of business. Now, the state of Georgia probably, it's a little different story than a small business owner. They've got deep pockets. So what's reasonable, what's an undue hardship on the state is a lot different than what would be an undue hardship on a small business owner. Defenses to employment discrimination. Remember I told you that Tuesday that some discrimination is legal. That's true. We don't let children drive 18-wheelers. We've discriminated against 16-year-olds from driving rigs. We discriminate against people without a pilot's license flying a plane. There's some other legitimate reasons that an employer might make an employment decision that otherwise might be discriminatory. All right, so these are legitimate. These are situations when the employer doesn't make up a legitimate reason. The employer says, they're exactly right. That's exactly why I didn't hire them or why I had to fire them. One is business necessity. I run a Catholic school. All the teachers are Catholic nuns or priests. An atheist applies for a job teaching third grade. I don't hire them because they're not Catholic. Normally that would be intentional discrimination, right? In this case, the school would have the defense of business necessity. I have a fancy restaurant that has bathroom attendants. I don't want to hire a male to be the female bathroom attendant. I can do that. Similar to business necessity is something called bona fide occupational qualification. That's things like I'm hiring a bilingual salesperson because the clientele or this customer base that they're dealing with in this position completely speaks Spanish, don't speak any English. So I'm putting as a qualification for this job that you must speak Spanish. TiVo applies, I speak no Spanish. I don't get the job, I sue for discrimination. That's a bona fide occupational qualification. You can't hire somebody to sell in a bilingual atmosphere that's not bilingual. That just makes sense. It's very similar to business necessity. I think they kind of have a lot of overlap. Seniority systems are also a legal form of discrimination. I guess that's true. if your company has a seniority system and it's written out, your employers are aware of it, you're consistent in how you apply it, and your policy says in promotion decisions, or let me say it a different way, whenever we have an opening, we offer it to current employees first. That's discriminatory against people who don't work for you yet who might want to apply for that job. But that's legitimate if you have a seniority system. If yours says we are going to promote, when we have an opening, we're going to promote. If we have, say we have 5 applicants, we're allowed to pick the applicant based on seniority. Who's been here the longest? Where companies get in trouble is when they're inconsistent with that. Or they make one decision today based on seniority, and then next week they make a hiring decision completely devoid of seniority consideration. That looks discriminatory, right? I get on the witness stand, Mr. Tebow, why did you hire Wilmot? Because he'd been there the longest. We've got a seniority system. Okay. Why didn't you promote Hare the very next week? He wasn't the most qualified. But I thought you made decisions on seniority. We do. Oh, only when it suits you, huh? Yeah. See? So, yeah, he's asking about, for my online people, he's asking about admissions, college admissions and race. There is a whole separate body of law on discrimination in admissions. And it has gone up and down over the years. The current trend in admissions is toward race neutral, gender neutral, any protected class neutral, away from quotas. But it used to be, I had to research this one time when I was working for my law firm right out of school. We had an admissions case, and the Supreme Court had said for a long time back in the 70s and 80s that was constitutional. It's been walked back a lot by the courts now, but it's a different body of law. Similar to that. Affirmative action is an example in this area that you're probably familiar with. There was, for a long time, the federal law held that if you did business with the government, if you were a government contractor, then you had to follow certain hiring quotas with respect to minorities or women or things like that. That's been eroded some by the courts too, but 25 years ago, it was upheld by the courts as constitutional. That's been eroded some since then. But that's a different area of the law, but a similar idea. Good question. Yeah, I think, I think this is just my observation. I could be way off base, but I feel like however many years ago, when discrimination, this became law, employment discrimination became law in the 60s. We used to think of discrimination on the basis of race, and in particular in this country, blacks and whites. And we used to think of discrimination based on gender, that women couldn't vote. The pay gap between women and men was off. There was a gap. But I think over the years, the protected classes that we have come to generally recognize have grown a lot more from just race and women, right? The protection that we would give today to disabilities is different than it was 20 years ago, certainly different than it was 50 years ago. Same for national origin. That's just something that I think that we just weren't as cognizant. It just wasn't as part of the, I don't know. But I feel like now where I'm going with that is it's almost impossible nowadays to think of for somebody to not be part of a protected class in some way or another. I mean, when I turned 40, I was like, yes, I've got a protected class. Age. But like I said, I think we all listed 10 characteristics. We could find protected classes that we all belong to. I think that's a big difference than when the movement or the idea of discrimination being protected by the law started. Sure.
I got an email this morning saying that pandemic emergency unemployment compensation had been funded an estimated
Had been funded?
and I was under the assumption that these programs had ended.
I thought they ran out too. I know they had a sunset, or I thought they had a sunset.
So I looked into it, and there's an email from the Department of Labor, Jose Rodriguez, subject is instructions to pay for ongoing workload-based administrative funding for the coronavirus aid relief and economic security.
So that's a federal program then. I don't know. I mean, I don't know the ins and outs of it, but it sounds like it's still going strong.
Yeah, it was supposed to end June 30th, 2024. But that's been amended like 3 times.
They keep extending it.
And then I read that it's like getting new work into something. I just thought it was interesting.
I think a lot of that, we got some money, the court system got some money, some federal money to help clear backlogs of cases from when the world shut down. And that ends this year. And I don't think that's been extended yet, or if it will be or not. But I think you're right. Some of those things have sunset, like the extension of some of the unemployment benefits did finally revert back to the pre-COVID requirements. But that is interesting. It is. It's hard to make sense of, and I'd submit to you that it's hard to these days know what's real and what's not real news. So hard to tell. The whole federal government spending is way above my ability to comprehend anything. It's just I just can't wrap my mind around all that. So that's all we have for lecture on employment law. Today at noon, your quiz will go live. It's on the lecture from Tuesday and today. And I'll go ahead and make next week's content available this week so you can read for next Tuesday. But make sure you read those 2 cases and the family leave article for Tuesday. And Benny's going to present to us on Romanian medical leave. Hungarian medical leave. Sorry about that. German medical leave. I'm looking forward to that. Why did I say Romanian? Is that bad? Do y'all have beef with the Romanians? You do? Like that's an insult? I'm sorry. I apologize. How bad is the beat? Like bad? Like bad? Oh.